Welcome back to SkepTech 2021. We're exploring the growing clash between government, technology, and free speech. And as part two of our program, we want to have a deeper discussion with more experts on Section 230, the 26 words in the Communications Decency Act that has dramatically affected all of us and our economy. So our speaker in the first part, David French, will serve as our moderator in this discussion, and we have three other panelists joining. So let me introduce them briefly. Dr. Mary Ann Franks is a professor at the University of Miami School of Law. She's an expert on the intersection of civil rights and technology. She's an alumna of Harvard Law School and the University of Oxford, where she was a Rhodes Scholar and earned a PhD. She's a fellow of the Yale Law School Information Society Project. They have some great videos on this topic, by the way. Dr. Frank's 2019 book was titled The Cult of the Constitution, Our Deadly Devotion to Guns and Free Speech. And as I understand, her upcoming book is tentatively titled Fearless Speech. So we look forward to hearing about what she's working on there. Al Sikes served as chairman of the Federal Communications Commission from 1989 to 1993, overseeing policy in the early days of the internet, and battling radio shock jock Howard Stern about free speech issues, which was all just before the CDA, Communications Decency Act, and Section 230 were enacted. Sikes later served as president of Hearst New Media. He's an alumnus of the University of Missouri School of Law and has served on the board of the Trinity Forum and founded the Read Alliance tutoring program in New York City, among with many other excellent projects that he's been involved with. Scott Lincicome is a senior fellow in economic studies at the Cato Institute in Washington, D.C. He's a senior visiting lecturer at Duke University Law School, and he spent 2 decades practicing international trade law at the firm White & Case. He is a BA in political science and a JD, both from the University of Virginia. So we welcome all these panelists, and I turn it over to David French.
All righty. So my job is going to be to ask y'all questions and get out of the way. And I'm not going to start with Scott because Scott is kind of a colleague at the Dispatch, so I don't want there to be any favoritism. Let me start with Mary Ann, and I would like to ask you about I characterized and I would like to ask you about to see if you agree or disagree and how you see things. I characterize some of the competing interests between right and left on the social media conversation as, I mean, perhaps this is an oversimplification. The right wants less speech regulation by social media companies. The left wants more speech regulation by social media companies, and never the two shall meet. And if they do meet, where they're going to meet is over some of the issues that don't actually drive the public debate. And I'd be interested to see if that's a framing that you think is fair, or if it is really missing some real nuance to the conversation.
I think it captures a lot of what is accurate about the current debate over Section 230, but I suppose what I would suggest is that there's more to be drawn out in terms of those differences, in that much of what the right is asking for as a solution is the government should control what the social media companies do. And that strikes me as being really a non-starter as far as this goes, that idea that politicians especially should be able to say, as you referenced, that they should say, I deserve a platform on this private entity, and I should be able to break all the rules of this particular platform and still have that kind of access. That just seems like a non-starter, not just because it's bad policy, but because it completely runs up against the actual First Amendment principle that you don't want the government controlling speech. You don't want the government forcing social media, private entities to carry certain kinds of speech. They have their rights of not speaking, and they have rights of association. This is something not just limited to social media companies, but we extend that to bakeries and to restaurants and to nightclubs and all the rest of it. Now, when it comes to the left, there's just so much going on there. There are a multitude of reform movements that are being called for, some of which are very well intentioned, some of which are less so. What I think is true is that what most of the progressive critiques are calling for is something along the lines of recognizing harm and injury. The idea being that the most meritorious arguments are, it's not a question of ideology. It's not that we don't like the speech. It's not that we find it offensive. It's that there is speech and conduct, because one of the major problems with Section 230 is that it treats all things that happen online as if they were speech, which is not something this is not a starting principle that we should use. But the idea is that the progressive critique is, it's not about offense, it's about actual harm. And it's about harm not only to a person's life if they are driven out of their homes, or if they are not allowed to visit the grave of their dead child, as happened with the case of some of the Sandy Hook parents, or someone's career is upended completely because of harassment or intimidation. It's about that kind of harm, and it's about the kind of harm to speech. That is, if we say we're going to not regulate harassment and we're not going to regulate intimidation or certain kinds of incitement or calls for violence, what inevitably is going to happen is you're going to crowd out speech, because far more than worrying about whether or not you're going to get punished by the government for your speech, worrying about whether or not someone is going to try to attack you or put details of your child's school online. Those are the kinds of things that really do make people not able to speak. So I think at least the most meritorious left arguments are, we have to care about injury, we have to care about actual harm. And it isn't really so much about politics, it's about power, and it's about being committed both to addressing harm and not giving the tech industry this incredible benefit that offline companies don't get, but also being committed to an actual diversity of opinion, which is to say, making sure that women, racial minorities, sexual minorities are not intimidated into silence because they will be harassed and attacked online, and nothing will be done to stop it.
Scott, you were a veteran of the Section 230 Twitter wars.
Sure.
Yeah. I'm surprised you don't have a little bit of, gunpowder in your hair, on your forehead right now, because you're constantly let me ask you this. Is there a Section 230 reform idea that you have seen that you have liked?
No, actually. No, my problem, quite frankly, and this kind of coming as a practicing lawyer, is how difficult I think it would be in practice to define terms, for example, like harm, in a way that would not create will make things very ripe for litigation, costly litigation that would impact startups and the internet economy and all of these things that are quite great, I think. But also in a way that would not simply lead to gaming and abuse. And because I think the beauty of 230 is its simplicity, and the real lack of exceptions outside of things that are just very demonstrably quite something that can be quite clearly monitored and policed through, for example, an algorithm, right? Child pornography being a pretty easy example. Beyond that, once you start slicing things differently, I think that it really creates a lot of problems. And again, I think it threatens to kill kind of the golden goose and the economy at large. And I think that it's quite different in terms of the brick and mortar physical businesses and the online business, because I think that the sheer scope of the problem, of the issue, is just, I think, it's categorically different. Facebook employs 15,000 people to monitor and employs AI to try to monitor speech, and they still aren't very good at it at the end of the day. It just strikes me as a Herculean and really an impossible task, especially then when you start trying to define certain things, creating more exceptions and the rest. It just seems impossible.
All right, Al, I would love to get you to weigh in here. And given your experience, I kind of just want to say, go.
Well, that's excuse me, that's very generous. I'm coming to you from North Fort Myers, Florida, having gotten a COVID shot about an hour ago, and being forced into a motel room to set up and be on a timely basis available for this webinar or whatever it is that we're actually on. Let me do this. Let me try to go beyond 230 to a degree, and let me set up with a couple of questions. Question one: what are the consequences of an outrage culture accelerated by algorithmic contagion? Or a question that perhaps is faced by Joe Biden: what are the consequences of leading a country beset by emotional polarization? So I'm just trying to put this in the context of people that have got a lead, as opposed to people that are like us, who get to sort of shout from the sidelines and say what we think and what kind of leadership we think should be exerted. I also would quickly say, as I jump from subject to subject, that one of the things that really concerns me is when you convert hate speech into let's say Pixar quality expression, and then you marry that to the NRA list, and then you marry that to people who have shown a penchant for violence, and you send that out, and what effect does it have? And does the government at that point have any responsibility? And so to me, to some degree, it comes around to a question of whether the government can outsource censorship, which is to a degree what the government has done. And I guess my answer is that in certain respects it can. And I think it should protect political speech. I think a blanket ban on Trump is wrong. I share Alex Navalny's point of view on that. Alexei Navalny, excuse me for the mispronunciation. So I don't think there should be blanket bans on politicians or organizations or political parties. I think that should be protected. But I do think that we sort of edge into an activity here when, as I say, you marry outrage with algorithmic contagion that the government has some responsibility for.
So Marianne, first, feel free to react to anything that was just said, but also I was wondering, is there a social media company that you have seen that gets it closer to correct in your view on on dealing with harm? As the harm concerns that putting aside government regulation for the moment, is there a social media company that you think gets it closer to correct or has practices that you think are closer to effective than others? I guess also in reacting to your fellow panelists, what's your position on the Trump ban?
Well, to start with the question about, first, reference to the comments already made about harm, of course it's difficult for us to determine what harm is, but that's what the law's job is, and that is, there's no other way to explain the exceptions that the Supreme Court has given us when it comes to the First Amendment. Forget about Section 230. Not all speech is protected. Not everything is considered speech. Those are, of course, not easy questions, but that's why we have laws to actually answer those kinds of hard questions. We have to articulate things like, why is child pornography harmful? Why is obscenity unprotected? And that's always difficult. So the first step, I think, is always to acknowledge that there's no such thing as a position of avoiding that responsibility. We've always, as a country, decided that there are some types of content that we don't think get this kind of protection. And the only question is, what kind of judgment did we make? And are we making fair ones now? So I think we can't shirk that responsibility. But and Section 230 has already got exceptions in it. There are these huge carve-outs for intellectual property and for violations of federal criminal law, which raises the question of, if you really just want the internet to be a free-for-all, why have those carve-outs? Why not make it so that truly anything goes online, which has never been the case? But to answer your specific question about, are there any companies doing well? I think I could say with some qualification that there are some companies taking promising steps, all of which I think are too late, and all of them I think are going to be too little, but promising steps. And one of those is, in fact, banning Trump from Twitter. This is a very late step, but it needed to happen for reasons that had much to do with reference with comments you made earlier, which is, this is not an ideological point. This is someone who has obligations online, just like everyone else does or should have, that we shouldn't, of all things, we shouldn't give the most powerful person in the country more leeway than the average citizen. So if the average citizen is going to have to obey certain terms and conditions, whatever those are, when it comes to a private platform whose services you are experiencing for free, I mean, not really free, because there's a different way to look at, what's being extracted from you, but let's say nominally free, you should not get exceptions for that. And Twitter was right to actually say, finally, we're so worried about the context of these remarks and the fact that people will die, that there will be an attack on democracy that will be in part facilitated by his tweeting on this platform. We have to take him off. That was the right thing to do. The problem is they left him up for 4 years, right? I think it's not an exaggeration to say that January 6th doesn't happen without letting Trump do what he did for 4 years on Twitter. So it's great that they took a step at one point, but they really should have taken it much sooner than that. And that the promising thing that Twitter is doing lately is acknowledging that there are forms of speech that chill other people's speech, that it's never going to be a question of just, let everybody speak and then that will be the best way to get more speech, because that's never how it works. When you let people who want to incite violence and harass and intimidate speak, other people don't speak, other people exit. And confronting that and getting rid of this really tired and just completely ridiculous idea that there's anything like a neutral platform, that Twitter ever was, that Reddit is, that 4chan is, that any of these are. Look at any of their terms and conditions, right? They all have anti-spam provisions. They all have regulations about whether you can criticize the moderators. They all have rules. And so if we're going to say something is censorship, let's not be selective about what we're calling that. It's selective to let a person break the rules over and over and over again. That's selective. If we're going to amplify certain content and make other content less visible, that's also selective. So if we're going to talk about regulation, acknowledge the fact that every single platform is doing it all the time, and not ask the question of, oh, why are you changing it? But rather, why was it ever this way to begin with? So I think there are some positive steps that Twitter is taking. I think that some of the younger companies like TikTok are doing interesting things in terms of trying to learn from other mistakes and try to get ahead of things like election misinformation and try to get a handle on really abusive behaviors, because they, to really sort of seize the mantle, the opportunity that Justice Kavanaugh was talking about a couple of years ago in Manhattan Corporation versus Halleck, which is private companies, private individuals have liberty. They have the liberty to make a world that's different from what the government would have you do, because they're not the government. And the saddest thing I think we see with these powerful companies and all the influence they have over our lives is them doing just a sad replication of what they think the government should do with First Amendment obligations. Why would we want to stay in that world, given how messed up and messy and frankly selective and indulgent the First Amendment is, and how messed up the government is? Why would you want to replicate that and not take advantage of the fact that because you're not the government, you can actually experiment and have better norms. You can try to figure out ways to actually let more people speak, higher quality content, and not have your site be overrun with child porn and death threats.
Scott, let me ask you react to anything you've heard, but I have two questions.
Yeah.
One, I want you to weigh in on the Trump Twitter issue, Trump, Twitter, Facebook. If you're on the Facebook oversight board, how do you rule? And the other thing is, so you're a libertarian. We know how you feel about the government regulating these speech policies. If you were running Twitter, how would you regulate speech on Twitter?
Right. So first, I have no problem with Twitter banning Trump. As a private company, I think they have every right to do that if they think that that's in their best interest, in the country's best interest, whatever. I believe it's their platform and they can do it. And I think that one of the issues that's key is that distinction that seems to get lost so much in the Section 230 debate online is the distinction between government action and private action. I think that it's perfectly fine for certain internet companies to have rather strict moderation principles and others to have less strict rules and letting the market generally kind of decide where that line, what's the best approach for those individual companies, for the consumers as well. I think though, going beyond that and having the government step in and kind of create one size fits all categories of exempt speech that is covered, speech that isn't covered. I think that's really where you're going to run into significant problems, because, you know, I think actually Marianne brought up IP. I think that's a good example. Now, I don't want to upset my fellow libertarians out there. I'm not an anti-IP guy generally. Somebody's going to report me to the libertarian headquarters on that, but you know, I'm not generally anti-IP, but I think again that is where there's a pretty clear kind of objective issue, right? Did someone post something that is subject to a copyright or whatever? You can report that. It's not that, you know, somebody's out there constantly monitoring for that, you know, that it gets reported and then that can be evaluated quite quickly and removed quite quickly. When you move away from those things and you start talking about subjective issues, I am emotionally harmed, I'm afraid, these types of things, that's where you have to establish not only the fact that you are harmed or afraid, but you have to establish that the action caused that. So you're establishing the action and the causation and the rest. I think that gets very, very difficult once you again step outside of these very kind of clear objective areas. The other thing that I found was interesting is that, I mean, I think it's kind of difficult to say that we are in an era without the most speech ever. You know, I think that the online speech and the discourse that we see on Twitter and everywhere else, on Yelp, Airbnb, and the rest, I think that there's never been a better time for speech generally. And I think a lot of that is, again, because of Section 230. Now, look, is it perfect? No, but that's, as you said, you know, it's messy. This is by its very nature, the First Amendment is messy. The internet simply amplifies long-standing problems we've had long before the internet ever really existed. It was simply a figment of Al Gore's imagination. So, you know, that I think it's critical that you know, when we think about, well, there's this speech is reducing speech. I mean, it really seems to me quite difficult to argue that given the current situation. And then the last thing, I just think it's when you talk about powerful companies controlling speech, my only reaction there is that new exceptions to Section 230, by empowering a new plaintiff's bar to go after those exceptions, I think would actually make these companies, whether it's Facebook or media companies or the rest, more powerful, because they're the ones who can actually afford legal teams to litigate these issues. They can afford the 15,000 content moderators and the artificial intelligence. You know, a single lawsuit has been estimated to run anywhere between $130,000 and $730,000. I'm looking at my notes here. I cheated, but that a startup can't handle that. Startups also, there's studies showing that they lose investment. They can't get investment without types of liability protections. Investors just simply, there's too much unpredictability in the market related to litigation and the rest. And so, you know, this is a kind of, I wouldn't say a dream come true, but these additional regulations could quite very well make these powerful companies even more powerful.
You know, one thing that I think is amusing about the online discourse is the amount of people who will complain that Twitter is Big Brother and Orwellian on Twitter.
Right. Josh Hawley, he claimed that he was the subject of censorship by social media companies and was, of course, saying this on Twitter. It happens all the time.
Yeah, it's been a while since I read 1984, but I don't think Winston Smith complained about Big Brother on BigBrother.com.
Right.
But all right, Al, let me ask you, because you said something interesting at the very end. It seemed to me that you were saying that the government should, in fact, mandate, for example, that there should be access for political parties and politicians to large social media platforms. So do you think that there should be an unconditional right of access of office holders to social media?
Well, not of office holders per se, but of speech. And, there is a line. And, Marianne spoke of it in the context of Trump. But I certainly would not have banned Trump for 4 years. I'm not sure where the threshold should have been, but I think it should not have been at the beginning of his administration or the beginning of his campaign. So I think political speech should be protected. For the most part, all of the networks and the underlying infrastructure are assisted by government. I just simply don't think that the government should outsource political speech censorship. But again, I think we're dealing, with something that was written 25 years ago, approximately, and now we're 25 years later, and we're at least 12 generations beyond what the people then knew. And that's the reason I think that we should be sort of beyond 220, or should be 230. And I think we should, notwithstanding your earlier observation, with which I agree, which is that there is maybe a Congress in name only, but not in fact, meaning one that can actually use some form of regular order to come up with solutions. But I do think there are a series of things that need to be done. This might be, for example, the best time ever for free speech, but it's the worst time ever for privacy. I mean, is there anything that should be done in the context of privacy? I would suggest that there are some things that should be done, but it can't all sort of form under reform to Section 230.
All right. Now, I think we'd part of the original plan was to start to take some audience questions. Do we have some good ones in now, or should we continue with the four of us?
Well, we do have some that have come in, and I would like to throw one question out, journalism related, which is under various reform proposals for 230, is there a scenario where implications for journalism as an industry affected by the rise of big tech, trillion-dollar companies that are platforms? Is there a scenario where it benefits traditional media publishers that have always curated information and reliable for some of the content they were publishing? Could we possibly see a more responsible approach to news and information? A boost to subscriptions to some of the local newspapers? Is that in the cards? I think Al might be interesting to hear from, as well as anybody else on that.
Well, pay attention to what's happening in Australia right now, which is attempting to do essentially what you have suggested, and that is to protect its news media by requiring social media companies to pay for it. And I don't think I would go there, but I do think that the IP, Scott mentioned earlier, the intellectual property, I think should be protected. And but it's a conundrum for newspapers, and so I think we're struggling to find answers in that regard. But I would go back to what David earlier said, which is that there's an extraordinary amount of free speech. I mean, Axios, I'll just use it illustratively, I think is a better newspaper than most newspapers. And so, but for the internet, there would be no Axios. And I could go through some other publications as well. And then, of course, you've got, the nameplates that have got significant digital income now haven't displaced, the need on the profit and loss statement for classified advertising, but that began to leave the newspapers with Craigslist. So that's certainly not a new phenomenon.
Anyone else want to weigh in on that question before we go on to the next?
Okay. Some of the listeners are waiting. I was waiting, looking through questions as so others are giving thumbs up and comments about some of the things people are saying here. One listener asks, could you see the Supreme Court ever ruling that Facebook, Twitter, et cetera, that these platforms are town squares and the First Amendment applies? Would the Supreme Court, as it currently is constituted, be willing to do so? I guess it's a question of really the court right now, how it would rule on these issues you're discussing.
Oh, I want to answer that one. That's a big no. That is just not going to happen. And you know, that was, and please, if any of you guys disagree with me, but I think that is A, not going to happen, and B, it's a deeply flawed analogy. These town square, these cases, historic cases in which private actors were turned into public actors, were cases in where the private actors were adopting core public functions, law enforcement, for example, or maintaining prisons, for example. You're talking about company towns where you lived under the jurisdiction of the company was equivalent to the jurisdiction of the state. This is an app. You know, Facebook is an app. There's a massive difference. But anyway, I toss it out to y'all to see if you've got any contrary or amplifying thoughts.
Not on the Supreme Court. I agree with you, but I think the whole public square regulated utility model strikes me as I don't know if the advocates have thought about what that would do to these businesses and to their innovation. You know, this is one of the most dynamic and innovative sectors in the U.S. economy. It employs hundreds of thousands of people. The output is, I looked at it the other day, is in internet publishing alone, it's 3 times the size of the entire U.S. primary metals sector. It's a very large industry, very innovative. Turning it into a regulated monopoly where it has a guaranteed low profit rate is going to, I think, would just kind of destroy so much value that Americans derive from these services. You know, there was a great study, I think about 2 years ago now, showing how much of individual consumers, how much you'd have to pay individual consumers to give up their Twitter, their Facebook, and the rest. And it ranged from $150 or so for messaging to something like $17,000 a year to give up internet search, what people say. So, you know, the value that we place on things and the impact that turning them into, you know, the postal service or whatever is pretty dramatic. And I just don't know if a lot of these folks have thought about that in terms of, you know, its effects beyond the legal aspects.
Marianne, I'd love to hear if you've had any thoughts along those, the utility regulation lines.
Much to add on the utility regulation lines. I think my intuitions are similar to yours about the idea of town squares and what have you. That case I referenced before, the Halleck case, was not about the internet, but it was very similar in the sense of you've got these private companies that are cable companies, and the court goes out of its way to say just because you are providing a service for other people to speak does not make you into a government. That is not, we might feel like Facebook is governing us, and in many ways it is, but it is not in fact the government. And we need to be very protective of that sphere of liberty that allows private companies and these entities to make decisions, their own decisions about what they want to have on their platforms. But I do want to speak a little bit to some of the other contributions being made about, you know, this assumption that we live in this kind of golden age of free speech, and just to be very careful about how we're measuring this, because as we know, the United States has a very peculiar definition of free speech, and the notion that the First Amendment is the best way to produce speech is just something that's taken almost as gospel among Americans. But, you know, other countries have done other things, and they, I think, would probably suggest that they too have free speech, and that you don't have to take the American view in order to get it. And really to really ask always the question of free speech for whom? Do we actually think when we look at Twitter or Facebook or Fox News or wherever we're looking, do we think all sectors of society are participating roughly equally in our free speech debates and discourse? Do we actually think that the most marginalized among us are in fact able to speak more now than they used to be able to? Do we not think that there's still a disproportionate share of public attention? Because we are living in the attention economy now. It's not whether you get to speak, it's whether or not anybody can hear you. And so if you've got major platforms of powerful people who are reaching more people than they were before, celebrities, politicians, what have you, is that necessarily the best time for free speech? I think we should interrogate that empirically and ask a lot more sophisticated questions about it. And I'd also just like to sort of underscore the fact that if Section 230 goes away tomorrow, it doesn't mean that Facebook and Twitter suddenly become liable for everybody's speech. It's an immunity shield of all the things that we talk about how the First Amendment will keep you from suing on these grounds, and how causation requirements and all the rest of it will kick out the suits on those grounds. Yes, that's exactly what will happen if you don't have this preemptive kind of defense. It's like stand your ground for the internet, right? It doesn't mean that if it goes away, you can't defend yourself. You can. So the question is, do they need, on top of the First Amendment, on top of all these other protections, do we also need a preemptive shield that says you won't even get to discovery? You won't even have to lift a finger in these cases, because it's a procedural thing, Section 230. It's not a substantive thing at all. Taking away Section 230 doesn't mean anybody is directly responsible for anything else. You still have to go through the whole process. And as to the questions of, what kinds of impositions should we make on these companies? There's this funny kind of back and forth about how, they can't possibly, regulate all this content. They have so much content. And I think sometimes about the offline analogies that we were talking about before, which is like, imagine a car manufacturer that says, if I didn't have to manufacture seatbelts and airbags, I could make 3 times, 10 times as many cars as I am right now. Why won't you let me do it? That's not really an answer to say we've got this incredible scale and scope, and how could you possibly expect people to regulate it? Maybe the answer is, if you can't make a safe product, then you're doing too much of it. You need to scale it back. And the idea at the same time that, the system will be gamed by those. If you do impose more regulations, the big players will just get bigger. As if the system which has let those big players get big isn't inherently tied up in the fact that they don't get sued for things, right? One of the natural ways to keep you from becoming either a monopoly or a quasi-monopoly is the fact that you never have to absorb the consequences of your actions, right? People can't sue you. You don't get a Facebook and Twitter without Section 230 standing in the way of anybody ever taking them to task. And so the idea that somehow, if they were given more obligations, that would really solidify their dominance. I mean, what world do we live in right now? And by the way, when we're talking about the risks that people take when they might publish someone's speech or boost someone's speech or amplify a certain speech, that's what private citizens have to do all the time. Private citizens can get sued. They don't get Section 230 defenses, right? So what we're thinking about here is saying that massive multi-billion-dollar companies need this extra special bubble wrap protection, but an average person, right, who's not necessarily hosting a platform, they have to run the risk of their speech, and they have to make a calculation about whether or not the thing they're about to encourage or profit from is going to mean that someone can sue them or run afoul of a certain law. So I just think it's good to underscore some of those essential parts of the Section 230 debate.
I suspect Scott has a thought or two.
I do. I'll go just through a few, I think, starting really at the last and then going backwards. I'm not worried at all about Facebook and Twitter or Google. I'm worried about the future, the next Facebook or Twitter, and their ability to become that. It strikes me as essentially climbing the 230 ladder and then pulling it up to prevent the next guys from having a chance. And in that regard, we hear about monopolies, quasi-monopolies, and the rest. There's 2 headlines here that I'll repeat, because I think they really give a good idea of this issue. First, from 2007, the very scary headline, "Will MySpace ever lose its monopoly?" We know how that turned out. The next is actually from a big tech critic this week, which says, "How social networks got competitive again. Facebook's surprising new challengers in audio, video, photos, and text." So there are competitors out there, and they are rising and challenging these dominant players. And I think that they benefit. Those challengers benefit from Section 230 and from that liability protection. And why do they benefit? It is not merely the cost of litigation. It is the threat of litigation. The lawyers out there hopefully are nodding. The mere threat of litigation can itself create quite a chilling effect, not only on speech and economic activity, but things like investment. Again, denying small players, not the big ones that have access to global capital markets and all the rest, denying the small guys the ability to grow and to become big. And I think that, the internet in particular is littered with examples of little guys starting from nothing and becoming big guys eventually. And in the space of online content providers, again, whether it's Yelp or Airbnb or the wikis or you name it, they are benefiting from these protections. And I would note that, it strikes, we have other contexts where we limit liability in, I should say we protect kind of in a way like Section 230. One that comes to mind are anti-SLAPP laws, right? That simply preempt lawsuits in order to allow for people to have, to be able to have speech and enable speech. And I think these are very good things that we allow this types of the business. And then I guess the only last thing I'll say is on the car seatbelt analogy. It really is something that, again, a car, an assembly line is directly under the control of the manufacturer. The manufacturer is producing the car, whereas platforms, they are not producing the speech. And that is quite different. And not only that, the number of cars is again dwarfed by the amount, the content, the amount of speech that goes online every day. It really is just orders of magnitude different.
Al, anything to weigh in on here before we go into the next question?
Well, I was just going to say, you're right. I mean, in the context that we're discussing, they're not producing the speech, but they're manipulating the speech. And they're manipulating it in an addictive way. And I just think we need to keep that in mind because these are not benign people. I mean, sort of rule one is that return on investment irrepressibly drives toward monopoly. Monopoly results in margin, or oligopoly results in margin. And so, the reason I keep coming back to believing we need to take another look at the overall Communications Decency Act of 1996 is I think this goes beyond Section 230.
We got some new questions rolling in. Someone writes, this is from for Mary Ann. If 230 is about power, how would you change or modify the law 230 to protect the most vulnerable and still be constitutional?
So I think a couple of things could be done. One of those would be directly on point with some of this conversation is to separate out why we seem to be so deferential to the tech industry, which, the argument that is offered to say, the analogies to say car manufacturers or hotels or whatever it is does not map because we're talking about speech. Well, one thing we could do is to actually make sure that Section 230 is only being used for speech, which right now it's not. So what you've got textually in Section 230 is a reference to information as opposed to speech. And what that has been used to do is to allow, for instance, an online arms marketplace that directly facilitates people who want to sell guns to people who can't pass a background check, and people who can't pass a background check wants to put them together and help them make that exchange. Being able to say, hey, we've got a Section 230 defense when someone gets killed because of one of these exchanges. Now that seems troubling because we've already got an incredibly capacious First Amendment that covers so many things. And now we're also going to allow these companies who are doing things online, everything from Airbnb bookings to firearms marketplaces, are able to sort of just implicitly say, well, what we're doing is speech. And that's why we have a Section 230 defense. So I would modify Section 230 to say speech, not information, so that if there's ambiguity, or at least make it one of the elements that you would have to show, that the thing that you are invoking Section 230 for is actually speech as opposed to a whole bunch of other things. So that would be one way to streamline some of this. It wouldn't solve everything because the First Amendment right now, the way that it's being interpreted, is all too often going to be interpreted in a way that will benefit the most powerful as opposed to the most vulnerable. So we're going to run into those problems. So the other thing I would do is to try to get at the other major structural problem with Section 230, which is the fact that it effectively sets up a completely inverted world online, specifically with regard to the principle of collective responsibility. That is, in the offline context, we have plenty of examples to show us that wrongdoing is not just the responsibility of the person who fires the shot or who makes the threat. In the offline world, there are all sorts of people who are not directly doing the bad act, but are facilitating it, are accomplices to it, are contributing to it, are benefiting from it. the hotel owner who doesn't want to spend money on having lights in the parking lot, even though we know that sexual assaults will happen in the parking lot if you don't put lights in, right? There's all kinds of ways we can say, you know, you've got store owners that have an obligation to make sure they clean up spills, or you've got laws that say bartenders can't keep serving drinks to clearly inebriated patrons. All of these ways where we say it's not just the last act wrongdoer, it's a bunch of things that have to do with foreseeable harm and whether or not a person or an entity that has control and could reasonably do something to prevent that harm chooses not to. What Section 230 is, at least the way it's been interpreted, it's been basically a blank check to anything that happens online to say, oh, that's out the window. As long as you're not the person doing the final act, you're off the hook. So I would change Section 230 to make sure that that's not allowed anymore, partly because that's presumably not what the law was intended to do. It is, after all, invoking the Good Samaritan in its very title. And the opposite of a Good Samaritan is the person who, you know, walks past the person who's bleeding out, or who, you know, rifles through his pockets and takes the change out of it, right? Those are not people that should be protected by Good Samaritan laws. So I would change this by saying you should deny the immunity of Section 230 to any entity that has exhibited deliberate indifference to unlawful conduct, so that we are cutting out those people who are just standing by, doing absolutely nothing when it comes to foreseeable harms, and make sure they don't get this protection. And again, this doesn't mean they become responsible for the thing. There are all kinds of questions we then have to ask about causation and about liability, but not to give them the preemptive shield, because that gives them absolutely no reason and no incentive to calculate in their infinite resources to make any provisions for trying to prevent foreseeable harm.
Thanks. There's a good follow-up that a few different audience members have been asking around this issue of panel. They're wondering if panelists, you know, what your solutions are. What aspects of proposed legislation do you like? I think in Mary Ann's case, as she just articulated, I came across a paper, I think from Stanford, where you even put red lines and edits on Section 230, which is interesting to look at. But now for other panelists to maybe to respond to what Mary Ann's thoughts were, and or to respond to proposed legislation and the audience member rights, are there certain restrictions on speech that you would agree with that are reflected in one of the bills?
Start with you, Al.
I was just, you know, I'm not familiar enough with the bills to, you know, to really answer that. So let me make a couple brief comments. One is the, you know, it was mentioned when I was introduced that I got involved with Howard Stern. You know, Stern's breach was of a preclusion of speech that was perceived to harm children, that involved sexual content, etc. And a guy in Los Angeles was taping all of his shows and then would send the transcripts for the FCC commissioners to review. Well, that was a great deal of fun, huge distraction. We found 3 of those shows, meaning the morning shows with Howard Stern, which were broadcast nationally on radio stations. We found those actionable and we took action. And over time, excuse me, the owner of the stations, it was sort of the anchor stations of the network, moved him over to satellite television, or excuse me, satellite radio, and put him behind a pay tier. So he got to continue to speak, but he couldn't continue to reach prepubescent children, especially young males. And so the whole foreseeable harm thing, I think, has some attraction to me, because I think we're in an area where there's a sort of a witch's brew that we need to be taking a closer look at in terms of what we might immunize or what we might choose to make actionable. I would also mention to this group, and I'm going back to David's opening comments, left, right. You know, I wrote the veto message for President Reagan, who vetoed a congressional effort to reenact the Fairness Doctrine after the FCC repealed it. And at the time, it seemed to be sort of evenly distributed between left and right as to who was going to be the most forceful in being able to bring political commentary to radio and television. Well, as it turned out, notwithstanding Al Gore's many efforts, Rush Limbaugh proved to be the most naturally talented. And over time, the left began to view the fairness doctrine as something that needed to be returned. So I wouldn't be a bit surprised to see in this administration some effort to return the fairness doctrine.
Scott, I'm imagining the fairness doctrine is a trigger phrase for you.
Yeah, I started getting the shakes a little bit on that. No, look, I mean, I think that what we've seen with the fairness doctrine, it's actually a pretty fantastic example of the perils, potential perils of 230 reform, which is that by imposing a fairness doctrine for the internet, I think you're inevitably going to chill speech, and you're going to chill speech likely in a partisan way, or at least, given the kind of power structures that are dictating what is permissible and impermissible speech. And again, we've saw that with the fairness doctrine, right? We've also seen in history, there's a great book I was just flipping through the other day about the politicization of the fairness doctrine and how it was used as a weapon against administration's ideological foes in the media. And that type of action is precisely what makes me so hesitant to allow that to happen to internet speech and to information provided through these third-party content providers. I think the other thing that's really important when we talk about holding these companies liable is the difference between action, something like a conspiracy or selling alcohol or selling a gun, and inaction, simply sitting there. I'm reminded of the finale to Seinfeld. Maybe I'm dating myself a bit here, right? Where all the characters got thrown in jail because they didn't help someone who was injured on the side of the road. Well, now imagine applying that very same law to the internet, but then millions, tens of millions of times every day. And the type of chilling effect that would have is, I think, inevitable. You would see companies simply decide, I can't control, I can't possibly moderate all of this speech, and therefore I'm simply not going to allow it. And the chilling effect that would have on individual speech and on economic activities, I've already mentioned, I think would be pretty dramatic. And that's, I think, a key difference between some of the examples that Marianne provided and I think what trying to add teeth to Section 230 would do.
Unless someone wants to weigh in on that one, I think a student sent in a question here on, oh, sorry, Al, do you have a?
No.
Okay. I think a student's asking, can the panelists, particularly Dr. Franks, talk about whether dating websites should be responsible for abuse that occurs from dating matches?
I feel personally attacked by this question, but I think that's a really hard question, and the devil would be the details there, right? It depends. What a lot of people think of, I think, in the context of dating websites and Section 230 are probably a case like Herrick versus Grindr, where you've got someone who had a vengeful former partner who decides to impersonate this Mr. Herrick and invite men to this person's house and to their workplace, and saying this person's really interested in sexual fantasies, sexual violence, etc., and led to extraordinary harassment and terrorization of Mr. Herrick. And Grindr was notified about this and essentially chose to do nothing. And so that's a very, I think that is one of those questions that we should have to face, which is to what extent is Grindr responsible when it knows that this kind of thing is happening? Then you can also think about the dating sites that are not engaging in background checks. And so you've got people who have a history of sexual assault who are hiding that on these websites. Is there implied safety on these sites that, should it be a standard that these dating sites actually make sure that the people who are on these sites are not, convicted of sexual assault? And if a sexual assault does result when the company failed to actually have a background check, should they be responsible? And I think these are all questions that don't have a preliminary answer. What it should mean, I think, for those of us who care about harm and care about trying to find structures in place that will deter harm, that it's not enough to say someone's been harmed. Can we figure out if there's any way to do something about it after the fact? If it's structural, if we know over and over again, social media sites, dating sites, et cetera, are leading to sexual assault and murder and incitement of violence and extremism, and you've got these companies that are pocketing money from this and doing nothing about it, those are the right questions to ask about how could the law possibly be working well here if that's what we're allowing to have happen. The idea that we don't ever punish people for their omissions, of course we do all the time, right? I mean, if we think about, David mentioned Title VII before, right? The entire premise of Title VII in some ways is vicarious liability, that your employer is the one who's in trouble if you're getting sexually harassed at work and you tell them and they do nothing. So it's not just about whether or not you are going to speak to the person, the individual who's done the bad thing. We have to ask serious questions about the structure, the environment, the place that encouraged this behavior, that allowed this behavior, that could have intervened and didn't. Those are the interesting questions. And if we were actually committed to a diversity of viewpoints, to democracy, to truth, to people being able to express themselves, we would care about those things, because there's no bigger chilling effect than dying or being threatened with sexual assault or being forced out of your home. It's not chilling effects on one side of the equation only. When you let that kind of conduct and speech run rampant and you let people be silenced by that, you are essentially saying you don't care about the freedom of speech of those individuals.
I've got another question just to keep things moving here as we wrap up our time in just a minute or two. Someone wrote a question for Scott, so singling out Scott. It says, what about the idea that social media companies actually benefit financially by stirring and at times fomenting, quote, fighting words based on their own algorithms? Is that a case that's foreseeable liability?
Yeah, I think that you would, again, it strikes me as something that proving that social media companies are attempting to incite violence strikes me as quite difficult, to put it the best. But I think it does raise an issue. And it strikes me, listening to some of the things Marianne said, I think that these companies have a very strong market interest, the market interest in creating environments that are safe. Dating sites in particular, for example, have a strong market interest in having background checks and ensuring that they are providing a safe environment. It is not merely the idea that they are simply, again, pocketing gobs of money by creating a health space, right? I mean, they have a lot of market incentives to do a lot of the stuff we're talking about, where I, again, get quite sheepish is by pulling the government into the mix and by either directly regulating those activities or just providing a kind of, the carte blanche to sue them for anything that potentially runs afoul of the new law.
What I'll propose here is one question I want to ask Al, kind of a quick question, and then turn it back to David if he has any final thoughts, and then farewell from Dan. So Al, you were at the FCC in the early 90s as the internet was really coming about. And there was this context of, the Free Earth Catalog and the Homebrew Computer Club and the future of what the internet could be, and the Electronic Frontier Foundation. And I know Marianne has talked about that too. I'd just love to hear your take about, kind of a short take on the where we are now, 30 years later, and where we could be in the future, if we, as you see it.
Well, I mean, what I did at the FCC was really aimed at creating the framework within which the internet could thrive, and mobile communications could thrive, and satellite communications could thrive. So if I look back, those are the things I talk about, not Howard Stern and the Fairness Doctrine, but about new cell phone frequencies, satellite radio, satellite television, what we call, not at the time, the internet, but the network of networks, as we called it. And I think we envisioned a lot of this. We talked in terms of a video dial tone, for example, which is certainly emerged technologically and realistically, on most parts, including tonight, where we have a video dial tone, if you will. So I see an awful lot that I think is just terrific. And I use, notwithstanding my age, I use much of what, Google and search and Wikipedia and I read the paper each morning on my iPad, et cetera, et cetera. And I see this universe flourishing, but I do see harm. I do think there is foreseeable harm, and I do think there's time to revisit some of these questions. And I guess I don't have the same, sort of severe allergy to the government that Scott has, because I saw, 5 FCC commissioners at the time, 3 Republicans, 2 Democrats, wrestle with Howard Stern suppression, if you will, meaning the few instances that were brought to our attention that we thought were actionable, and they did it in a very sort of almost patriotic way. So, is Twitter or is Facebook or a variety of others? Should we be outsourcing censorship? I'm not sure I agree with that.
Maybe we just close with a similar short remark, because I think Marianne and John Perry Barlow and your sort of different take, I think, is quite interesting. If you could talk to us about how you saw the internet then and now in the future.
One of the amazing things about reflecting on early cyberspace idealism, whether it's John Perry Barlow or really in the findings section or the goals sections of Section 230, right, and that glorious 90s of saying we're going to have a utopia for free speech. I think the really seductive thing about that is that it just presumes so much. It lets us all feel as though we're all in the same boat together, and the internet could be this wonderful thing, or is this wonderful thing where speech is unfettered. But what is inevitably true about those kinds of accounts is that it's always, who are you speaking for and of? And for Barlow, let's face it, who he was thinking about is people like him. He was thinking somehow people like him, white middle-class male, didn't have enough opportunities for speech. They needed more somehow, and the internet seemed like it was going to provide that. He spoke of oppression. He spoke of how the chains were coming off and how finally they were going to be able to speak. And it makes you wonder, well, why was this group of people so sure that they needed more and more frontiers of speech, instead of being concerned with, well, why not have the internet upend some of the presumptions we've had about who gets to speak and who doesn't? I mean, there's some kind of throwaway lines in the manifesto about we're not going to be worried about class anymore, not about race anymore, nothing about gender, because that apparently wasn't important to him. But the idea being, well, what is it that you're trying to revolutionize here? What is actually going to look different about the internet? Or is it just going to replicate some of the same offline harms? And that's where it leaves me, right? Because of course there's so much potential and rich experiences offered by internet communication, but it should always come back to the question of what has actually changed. Has power changed hands significantly? And I'm not really speaking so much about politics as I am about who is in charge, who is calling the shots. Whether it's in government or whether it's in social media, are we not still having our entire imaginations framed by a very small group of people who look really similar to each other and who seem to be continually surprised that the products and services and promises they're making are being used to send death threats to people and to harass people and to live stream rapes and murders. And there's this constant sense of shock of, well, we just had no idea this would happen. We'll get right on it. And at some point you have to ask yourself, it's not a bug, it's a feature. You've got to stop making structures like this that simply discount the experiences of everyone who's not of your race and of your class and of your and of your gender. You really have to think about the people who are actually struggling to make themselves heard and to be secure enough in their worlds to be able to speak freely and to actually participate in civic discourse and actually commit to democracy. So if the answer is, we think this is as good as it gets, what we've got right now, we've got 4 years of this kind of totalitarian path, and we've got an insurrection at the Capitol, and we think that that's the best we can do with all of the great potential we have with the internet. I would just say I'm not in the camp that says that's the best we can do. I am absolutely convinced that we can actually use the extraordinary powers of the internet to do something radical. And that radical would mean to shift power away from the people who have always had it and to actually open up democracy and autonomy and truth to those who have pretty much always been denied those channels of communication.
Thanks for the civil discourse we're having here. And Scott and then David, could you give us your sort of summary thoughts?
Sure. I think that, I mean, to start, there is no utopia. I think it's really critical that we understand that there has never been a free speech utopia, and there never will be. I think it's instead really critical to understand that speech, like life, is messy. It is complicated. It will produce things we don't like. It will produce things we love. But the question is really, what has Section 230 done for the internet, for speech, for the economy and the rest? And what might repealing or curtailing it really do? And I think that it really is quite clear, looking at what Section 230 has done, in good and bad, that repealing or curtailing it significantly would do more harm than good. Certainly, that type of repeal or serious reform certainly would prevent some of the horrible things that have happened. I think it's undoubtable, but it also would do a lot of other things. And that is really where what makes me so hesitant to endorse any of these, really the more significant reforms, because it would chill speech, either by forcing sheepish internet companies to hire teams of moderators, or to delay content, or simply not to allow content. It certainly would lead to less speech overall. Maybe you think that's a good thing, having read some of the things on Twitter, certainly not on my account or David's, but on other accounts. But I don't. I think that more speech is better speech. And I think that this would clearly curtail that. But it also, as noted, would really put government more in charge of our speech in terms of interpreting subjective terms, like, for example, political neutrality. Well, who's going to do that? Well, it's going to be someone in Washington dictating that, or a judge dictating that. And that, I think, again, has significant implications for not just online speech, but again, for free speech in general, and for partisanship, as again, bringing up the Fairness Act again. And I think it's inevitable, again, that we would see lawsuits, and lots of lawsuits. It is easy to point to things that are objectively bad, like child pornography, and easily identified as stuff, well, we don't want that. But the problem is that the vast majority of stuff out there on the internet is not self-evidently wrongful or illegal. And that creates a ripe area for quite vigorous plaintiffs and their lawyers to go after deep-pocketed tech companies, new startups, and the rest. It also, I think, would create a less vibrant environment on the internet in terms of, for small businesses, new businesses, for consumers, and the rest. And look, it's not a revelation that regulation hurts consumers and benefits deep-pocketed incumbents at the expense of smaller upstarts, but that's typically, or that's, I think, quite likely what a significant reform of 230 would do. And you don't have to take my word for it as some, libertarian type, right? I mean, the Brookings Institution has said quite similar things as well. And a lot of folks on the left side of the aisle have said similar things about Section 230. This is not merely libertarian fantasy talk here. There are a lot of folks who think that this would hurt consumers, would hurt small businesses, would empower big tech, and would chill speech. And then, I think the other important thing to note is this, I think, would empower legacy media as well. So it's not just about upstarts in the business space and Airbnb and all these cool things, also is about legacy media. I think that, to the extent we are concerned about the control of speech by a select few, 230 protects small players in the media market. It protects media critics and the rest. And I think that is something that would, again, be diminished. So, it's critical when we think about these issues, again, not to think about utopia and not to simply think that we can create that, but instead to understand that it's going to be messy and complicated, and to understand not just the things that 230 has given us, but also the things that repealing it or reforming it might take away.
Scott said a lot of what I was going to say. I just want to say two things. One, to deal with the utopia point. This is, if there's one thing you take away from this, this is a complex issue. It is a complex issue. And the very complexity to me makes me more skeptical of the top-down federal solution. That in fact, I feel like it is going to be much more in the public interest if a variety of private actors are attacking the complexity of this thing from a variety of angles, that the very multiplicity of approaches is one that's going to be much more beneficial to us. I think, even if you're just even setting aside sort of the zone of protection we should keep around the First Amendment, around First Amendment doctrine, I think the very complexity mitigates against a top-down federal intervention here. Number two, one thing that I think is, Marianne, I think is very, very rightly focused on how do we provide meaningful free speech rights in historically marginalized American communities. One thing that I would say, though, is I think in the Section 230 world, especially married to social media, we have seen historically marginalized communities have a bigger voice. And I think that we have seen this and I'll just give you one really good example of this. I think that the combination of the smartphone and instant access to social media has elevated the issue of police brutality in a way that has never been, at least in my lifetime, that we have to deal with it in a way that has begun to cross partisan lines in dealing with issues of police brutality and civil liberties in a way that we've never before. And I don't know would have been possible without that combination of the smartphone and virality on social media. So I think that is not something that came from the New York Times down. I think in many ways it came from, literally in some cases, from the streets up. And so I do think that there is a way in which that I do think is just as a matter of how many people are speaking and who has the possibility of being heard. The current system, the Section 230 system, is superior to any alternative that I've heard. And I'm not somebody who thinks Section 230 is divinely inspired. I'm happy to listen to proposals for reform, but my issue is I've yet to hear something, a proposal for reform that A, deals with the actual complexity that we have, and B, that actually will advance the interests proposed without severe negative knock-on effects.
Thanks to everybody. Thank you so much, David, Marianne, Scott, and Al. Thanks to all those who listened. We will send an email with the video, as well as maybe some links to some of these speakers' books and research. And I want to thank Acton Institute as well, and turn it back over to Dan for the final word.
Well, thank you, Paul. I'm reminded of the social critic and media critic Neil Postman. He reminded us after listening to this conversation, he reminded, the clearest way to see through a culture is to attend to its tools for conversation. And that social media, in every tool we create, an idea is embedded that goes beyond the function of the thing itself. And I really think that's what we're talking about. We need to remember that these issues aren't simply issues of law, politics, and economics. They're ultimately cultural and speak to the changing ecosystem that has emerged over the last 20 to 25 years. And so I really do want to thank David, Marianne, Al, and Scott for adding their ideas, to these, what everybody has said is a complex topic. We appreciate your insight and your angle and your thought on these topics. I want to thank those of you who tuned in tonight to listen and think with us on these issues. Please stay in touch with the great work coming out of the McCandlish Phillips Journalism Institute at King's College. Paul Glatter and his team are doing some great things. And on behalf of the Acton Institute, we're really thankful to co-sponsor things like this. Thank you for tuning in, and we look forward to hearing from you in the future. Have a good night. Thank you.